Counsel?
Well, I guess I would move to dismiss again. The petitioner has filed a prayer for relief asking that the court strike the former dismissal, indicating in her pleading that she didn't receive notice of the court's notice of a hearing. She somehow found out about it the day afterwards, according to her own pleading. I'm not quite sure how that happened, but in any event, my understanding, I was here, I guess it was last week, and the court took great pains to go through with the clerk present on the computer to make sure that the petitioner had been served with appropriate legal notice. My understanding is that happened. I don't have the petitioner's home address because it's sealed. Petitioner's counsel at the last hearing in 2012, Catherine Monroe, and she apparently submitted as an Exhibit C here from last year's hearing, a notice of decision, clearly indicates she's counsel of record. As far as I know, she never withdrew. I filed a objection and requested a hearing when the domestic violence order had been extended, and I copied her lawyer on that, put that on the record the last time, and as far as I know, the court indicated on the record that it had served her last known address and the current address. So I believe, Your Honor, that the burden of proof is on the petitioner to establish to the court's satisfaction that she was not properly served. I think that burden's already been met by my side, even though I don't technically have it.
Certainly, Your Honor. The petitioner filed, having spoken with the call center, trying to figure out what was going on last week. The petitioner filed a change of address form with the court on June 26th of 2013. That was what was indicated to me by the call center. On July 2nd of 2013, a hearing notice went out. However, it was not received by Ms. Mercier, nor was it copied to Catherine Morneau's office, as that is where I work. We did not receive a copy of that hearing notice. I don't have access to the court file because it is with you, Your Honor, and I did not speak. We were obviously not here at the hearing last time, so I don't know what address was put on the hearing notice. My understanding is there was potentially a Litchfield address put on the hearing notice, which is nowhere near where she currently is residing.
One of the issues at the last hearing, counsel's right, we took the time to go through the entire file.
Mm-hmm.
My concern was whether or not your client received notice.
Certainly.
And it appears that what happened is your office, if you're, as an officer of the court, you're telling me you didn't receive notice, I believe you. I don't have anything here to show that you did.
Correct.
But to be perfectly frank with you, I wouldn't be able to prove that you did or didn't. You know.
Certainly, Your Honor, and if we had received notice, we would have been at the hearing last week.
Well, what concerned the court last week was if I had an attorney of record, why wouldn't one of you be here for an appropriate motion to continue, motion to excuse attendance, or motion for telephonic hearing, something. There's nothing in the file.
Correct, Your Honor, because
Right.
we had no idea when the hearing was actually scheduled. I know that Ms. Mercier was checking her mailbox every single day because she had filed the petition on her own and therefore believed that the notice would go to her even though we were still attorney of record. And we had not received anything in the mail. In fact, my understanding is that the court called Ms. Mercier directly before calling our office to inquire as to the whereabouts of her the day after the hearing.
If I could address that, Your Honor, I don't think the court did anything wrong. I think, from my understanding, is the petitioner filed this pro se. The court was under every right to believe that the mail should go to her. And even if there was, in another hearing, a record, I think we've covered both bases. The court sent the record to the petitioner. I haven't heard any offer of proof that it has anything to do with the court not sending it to what the record of address was. There was some mention of Litchfield. That's absolutely incorrect. The petitioner hasn't lived in Litchfield for years. Through the divorce case, which is, of course, on appeal right now in the Supreme Court, it was common knowledge that she lived in Nashua, and this wasn't anybody sneaking around trying to find out where she lived. She lived at Shattuck Street in Nashua. That was common knowledge through that proceeding. No one could talk about it again legally. So the court sent it to the correct address and made due diligence efforts to do that. I covered the other bases, which is I sent it to counsel. Now, I think they haven't met their burden of proof here. What she said was, and this is critical, she said, we never received it. The issue is whether it was sent, and sent to the proper address. There could be many reasons that she didn't receive it, if that's to be believed. And I haven't heard any offer of proof, from actually the client here, that that was the case. And my concern, frankly, is that it's a manipulation of the system here to keep this thing going onwards. Frankly, that's happened in the past, and I'm very concerned about that. We did everything we were supposed to do. The statute is mandatory. She's got to be here. She wasn't here, and the fact that we're all here today is not good enough. And I think the court covered these grounds. I haven't heard any explanation other than, well, we didn't get it. And we don't really know where it went, and I called the call center, and they said this, that, and the other thing. I object to that. Even though it's a judicial branch, you got to get the proof. And they haven't proven that, not even by a preponderance at this point. To my client's severe detriment. And he's got constitutional rights here to state. They haven't met their burden, and it has to be dismissed with prejudice.
Counsel?
Your Honor, first of all, the fact that counsel is saying that he sent us something, he didn't send us a notice of hearing with a hearing date or telling us when the hearing was. I think he's talking about his objection. We were certainly on notice that there was going to be some kind of hearing, and we were doing our due diligence to make sure that we knew of that hearing. We didn't call the court every day. However, we also don't have, there's nothing in the file that indicated that we were copied on the notice of hearing, to my knowledge, and Ms. Mercier did not receive the notice of hearing. I don't know what address it was sent to, if it was sent to her correct address, because I don't, as I just said, have the file in front of me, and you had it this morning, or this afternoon, so I was unable to check. Based on that, she followed the appropriate court procedures as far as filing the.
Counsel, why don't you approach? If you're an issue about the rest, the opportunity to check.
Thank you. You were not copied on the notice of hearing for the August 13th date, as it indicates in here.
I agree that there need to be. I don't want to argue with the bench appropriately, but the point was that the court provided a notice of inquiry. She filed a petition pro se. But I covered it doubly by notifying them. And I heard two things. I'll step back a little bit. I heard two things, Your Honor, that concern. One was counsel said, well, we did our due diligence. We knew there was a hearing. We didn't call the court every day. That's exactly what they should have done. They should have called the court every single day and say, we are in this case, we still have an appearance, and we know it's a hearing. When is it? They didn't do that. And the second thing that happened is that counsel just said, well, I don't even know if we had the correct address. I have no idea. Counsel certainly is privileged and privy to her own client's information. The client's right here. And I haven't heard anything that disputes anything that I've said here today by way of proper proof. I'm going to, again, request that the case be dismissed with prejudice. We've now checked the file on the record, and the court has done what it's supposed to do.
Well, my understanding, Your Honor, is that her address wouldn't be in there because of the and therefore, without looking at the actual unsealed address, I don't know where the court actually sent the hearing notice. It does say copied Honey Mercier.
One of the issues, counsel, and I think that Duggan is a point that's well taken. Your client needs to explain to the court whether or not, I need to hear from her whether or not she received, Ma'am, just before you answer, and I don't mean to direct
That's
questions
Your
to
Honor.
your clients directly. But what I need to hear, please understand, your attorney is making an offer of proof. I think Attorney Dunn's position is well taken. Your attorney is telling us what you would testify to. I need to hear from you whether or not you received that notice.
I did not receive it. I still am checking my mail to this day, and I still have not received anything.
After you filed this motion, you filed it pro se.
Yes, sir.
Did you contact your attorney and send her a copy?
I did.
Yes, Your Honor, a copy of her petition?
Yes.
Yes, Your Honor.
Your Honor, if I could just finish up on that, there's two moving parts to this. One, you've got the testimony of the petitioner saying I never received it. It's really a credibility issue here that I've got no ability to cross-examine her on, because
You can't just prove negative.
right, so it puts me in an untenable position with constitutional rights at stake here, serious ones. That order was for 4 years in a parenting situation. These are very serious matters before this court. And the second thing is that I thought I heard the petitioner say, as soon as I did this, I called my lawyer and passed the baton. And with all due respect, nothing was done to pick up that baton, and it has severely prejudiced my client. The proper proof was that, well, we didn't call the court every day, or we didn't know. I don't know what the address was. If anybody could get access to what the addresses were, it would be the petitioner's counsel.
We just checked, and it was mailed to Litchfield address. And we don't have a change of address form from Mrs. on June 23rd.
June 26th, Your Honor.
June 23rd.
June 20.
June 23rd, 2013.
The pleading indicates it was June 24th or thereabouts.
We don't have it. And Attorney Monroe, you came on August 14th. So the problem that we have here is that in common case matters, when you have somebody who's pro se, they hire an attorney, and they start filing matters pro se. When that comes in, the clerk's office, first thing they're going to do is they're going to look at the information that the pro se person provides, and they'll mail it out to that address. So what I have here is I have, at least it's in the system, there's no reason for me to doubt that the person that inputted the information into the computer system, they would do that as they sent, contemporaneously with sending the document that it was sent. So I have a pro se individual who files a motion. The court sends the hearing notice to that pro se individual at the last known address. They then notify their attorney. Even though you have an appearance that is still basically in effect, it's in effect was withdrawn, or the case is closed. The case isn't closed because it's an ongoing petition. At some point, there should have been.
Your Honor, if I may suggest what should have happened is when the petitioner filed her petition, she should have made sure that her address was current, particularly in light of the circumstance, Your Honor, where the family division case is in Nashua. She apparently has moved once or twice, I don't know how many times. We know there's a court rule that requires her to update her address. She clearly did not do that in a timely way, number one. That's an undisputed. The second issue is, did she actually do it at all? All you have is her offer of proof that she did so. There's no court record, and I respectfully suggest that this is not a living playing field. It's like the Vail rule from law school, where the premise is that if the court clerk didn't get it, that's the premise, and you've got a burden of proof that you have to move. So the petitioner, in my view, doesn't start out here, she starts out here. She hasn't even moved it to 50-50. And again, the backdrop is a constitutional right that my client has in this case. Now,
I understand that your client has done, again, I'm not taking the sides here, I'm talking strictly procedurally. Procedurally, your client's done everything he's supposed to do.
Sure.
There aren't any issues there.
Then I'll sum up with this. I believe that procedurally, the petitioner has defectively failed to notify the court on a timely basis of her address. The fact that the petition was sent to her former address is her fault. It's her obligation affirmatively to fix that. She did not. There's no proof that she actually went forward and actually did update her records, as evidenced by your court clerk just indicating to you, which I can take, suggesting you take judicial notice of on record. And at this point, they haven't met the burden of proof to demonstrate that they have complied with the statute of these court's rules, and I request that the case be dismissed with prejudice.
Counsel, one last minute.
Your Honor, as far as the procedural rules, leniency is given to pro se's, which she was at this time. Our appearance was still on the record, and the notice should have also included us, which it did not. In the domestic violence protocols, it allows for a filing of the petition after the original order has expired under 9-13. If the court would prefer to move forward as if the original order expired and we're filing a new order after the original petition, after the original order has expired, and proceed on that basis, that is fine. It is essentially the same standard for an extension. We would be just showing good cause today. If procedurally the court is more comfortable with that based on the procedural calamity that has transposed, then counsel is prepared to move forward on that basis.
This area of the law, as the criminal area of law, the procedure matters because the rights are behind it. You know, if this was a civil case and the order notice didn't go out, and you move to strike and all that. But this is not that situation. This is a situation where we've got constitutional issues at stake, criminal, and it's criminal nature. And they have not met their burden to show that they did crime.
Well, counsel is saying that if I grant the request, she believes, if I'm quoting you correctly, counsel.
Yes.
Monroe.
It's Attorney Perry. I'm here for Attorney Morneau.
Oh,
So
I'm sorry.
that's okay.
I've been calling you for 20 minutes. I apologize.
It's okay. I don't typically try to correct you.
Attorney Perry, I apologize. But Attorney Perry's position is that her client can still go forward with showing a good cause.
Correct.
I don't think she can demonstrate good cause. I would leave that for another day to see if she can demonstrate that. I'm not sure they can.
Counsel, how are you going to demonstrate good cause?
Well, Your Honor, good cause shown for an extension in this case would be based on several incidents. During the former restraining order that lasted until June of 2013, in September of 2012, my client moved into a new residence which no one had a knowledge of. She hadn't even updated the post office yet in September of 2012. Her son River, their son River, came home from a visit with his father. Within the first 2 weeks of the move, he indicated that his father had pictures of the residence in which my client was living on his computer. The reason that my client knew that he had pictures of this residence was because their son would point out different areas and say, oh, this is what I saw on Daddy's computer. I saw this on Daddy's computer.
With all due respect, I'm going to object, Your Honor, because that will really sort of going past the process here. She wants to file.
It's hearsay, sustained. Go ahead.
Well, Your Honor, I would rebut that in that hearsay is allowed in domestic violence proceedings.
Yeah. And 11D3 of the Family Court Rules should say you are allowed to have hearsay in certain circumstances. This is a material fact. The problem I have is that you have an out-of-court declarant who's also a juvenile who's making a statement or relaying information to one of the parties. Under the circumstances, I have a problem with that.
Understood, Your Honor. On September 25th of 2012, Jared called off his son's medically necessary surgery. My client, Honey, was forced to go through the court system in order to facilitate that surgery. That clearly indicates a control issue as to him.
Counsel, right there. Forget who we're talking about. If either party didn't agree with a medical procedure, wouldn't either party have the right, as a custodial care parent, to object to that procedure?
Absolutely, Your Honor, except for in this particular case, the way in which he went about objecting it, he forced my client to have to use the court proceeding and go back to the divorce court and have Judge Ryan order her allowed to be able to do the
Same
surgery.
objection.
Okay, I understand. Next issue.
In January of 2013, you know, there was, my client found out that her son had been allowed to watch a very violent video about a father who shoots and kills his wife.
Same objection of hearsay. I mean, now we're talking about a 4-year-old kid who's talking about some video somewhere. That's a perfect fodder for a GAL in a different proceeding, but not this one.
Okay, did your client contact, file the appropriate motion with the court or contact DCYF if she felt that the video was excessively violent or there's issues relative to his custodial care of the child?
Your Honor, they had a hearing in January. I don't, for the national court, I'm not sure if she addressed it in that hearing or not, but that was the hearing. Also at that January 31st hearing, Jared was testifying about my client's residence and where it was, even though it was sealed with the court, and there was no way for him to know what that residence was.
Objection. That's still hearsay. That's still an out-of-court statement often for the truth of the matter asserted. It's not, and that's a judicial proceeding. If you want to bring in a transcript and put my guy on the stand and impeach him, I mean...
I think your objection is best evidence.
It's best evidence, it's relevant, it's hearsay. And not only that, we're so far afield from the issue here, which is, can she meet that standard?
Yes, counsel, I understand.
Okay.
I have no circumstances. This is a domestic violence petition, and the court has a certain amount of leeway, and I believe that it's within my authority, all right, and under the statute to allow Attorney Perry to continue. So I meant, how many more do you have? I just want to make sure I understand.
Correct, Your Honor. I have essentially two more incidences.
Why don't you tell me what they are?
The first, well, they're all combined actually. These involved a visitation of Jared and his son. The visitations currently, the drop-off and pickups occur at the Hillston residence, where Jared was ordered to stay inside and not even look through the window when the drop-offs occur. On two separate occasions, Jared has been outside the residence. One was this past Sunday, August 18th, 2013. Another one occurred...
I just want to note for the record, the order was lifted at that point in time. Yeah.
I understand.
However, the order in the divorce proceeding was not. When my client had to carry her son in to the house on several occasions, Jared was right there waiting for her at the door at least twice. Essentially, Your Honor, for the courts, there was also a YouTube video that Jared posted with an image of his crying son talking about this domestic divorce case and the domestic violence case. I have the link and the posting date of that for the court. I have provided it to Attorney Duggan.
Several objections on that. One, that is beyond the scope of the original domestic violence petition. It's the four corners, whether it's a renewal or not. This is something I saw this morning. Two, it's best evidence rule. Three, relevance. And it has to be stricken for the first reason and the second reason.
I'll take that under advisement. Did counsel anything else?
Yes, Your Honor. The court in the family division case, Judge Ryan did indicate that in his order from April 19, 2013, that the respondent has a pattern of lying, manipulating, and misrepresentations to the court.
Thank you. Counsel.
A couple objections. One is, my understanding of what that exercise was to establish good cause why she should be able to file an extension to it, assuming that you rule in my favor. So I didn't hear one piece of evidence or argument that addressed that issue, not one. Two, putting that aside for the sake of argument, The only two things I heard that weren't sustained by way of objection was that the petitioner had a problem when she herself carried her child into my client's house. I don't see how that, in any way, shape, or form, demonstrates that she feels in fear for her safety currently, or is being abused, or there's otherwise good cause under the statute. You know, what the restraining order works two ways. She can't walk into his house and then say, oh, that was a problem for me, practically and under the law. Absolutely. So that doesn't get her, in my view, anywhere. The YouTube video, I again have objected and moved to strike it, but apparently this is something that's posted by a fellow by the name of James Lewis. And it's not by my client. This says Jared Stevens on the top, but the person who posted it was James Lewis, who's posted some videos. One. Number two, Mr. Lewis has an absolute right in the First Amendment to post anything he wants, as long as it's not harassing to a particular individual and violates some state or federal statute, which I haven't heard any allegation of that, nor have I heard any allegation. Mr. Lewis is acting on my client's behalf in an attempt to intimidate, harass, or otherwise violate the protective order that was in place either in the civil context in the divorce case or in this case. So in my view, clearly the petitioner has not met her burden of proof on the merits to demonstrate procedurally that this case should be here, it should be dismissed. Second, she hasn't demonstrated good cause under the statute to show that it should be extended. She's offered no evidence whatsoever on that issue. And or substantively, I again request that the court dismiss the case with prejudice.
Counsel, I'm going to grant your request. Perfectly clear here. Ma'am, I understand under the circumstances, though, there are two issues in this case. The first one is procedural. There's an issue of whether or not you received notice. And even if you didn't receive notice, you had an attorney file a pro se plea. Your attorney stated that you tried to call the court, and there is an issue whether Attorney Barrett and Monroe called every day, or what steps they took to ensure that your rights were protected. I don't believe it's fair to lay that on the clerk's shoulders that they're required to monitor each case file, and if they find a pro se person file a petition when they are urged by counsel, notify counsel. It's just, unfortunately, we don't have the manpower, and I just don't think that's realistic. In regards to the good cause shown, the statute is very clear. Under RSA 173B5, 6, and 633:3, subsection 3C, good cause is to provide safety and well-being, and you have to be able to show them at first, and the current conditions are such that there is a concern for the safety and welfare of the plaintiff, and that would be present reasonable fear. And we have a number of issues that we've raised. I don't see a clear violation of the final law protection and an allegation of attempt to intimidate or harass that you can demonstrate that this gentleman has perpetrated. I don't see it, and under circumstances, Attorney Duggan is correct. Statutorily, I have no other choice but to dismiss this matter.